Mr. Keating.
Good morning, Your Honor. Michael Keating, together with David Clough, on behalf of the appellant, Massachusetts Turnpike Authority. This case is an appeal from the affirmance of the allowance of a motion for summary judgment, the affirmance in the appeals court. The appellee in this case is a retired employee of the Massachusetts Turnpike Authority who seeks to recover from the Turnpike Authority certain benefits that he claims he is entitled to under a sick leave policy that the Turnpike Authority had during the time of his employment. The question presented in this particular case is whether the defendant's personnel manual or employee manual gives rise to an employed.
Mr. Keating, at one point you argue that this was a gratuity. Do government agencies normally give gifts to their employees?
Well, I think it's just the use of the phrase gratuity, I think, is to distinguish this particular benefit from salary or from some other thing that's related to the labor that the employee performed.
Well, what did the employee, the plaintiff, agree to? Did he agree to anything in writing when he took the job in regard to the policy manual?
He did not, Your Honor.
Okay, so is there any signed document that the manual becomes part of the contract?
There is not, Your Honor.
So what was the deal? What was the arrangement as far as the manual?
The manual had a provision in it which stated in substance that for a person with 10 years of employment experience, that a certain number of sick days that were unused would be credited to that particular employee, and when that employee retired, he or she would be entitled to either or to both of a payment against their group health insurance as a retired employee, or a cash payment, and a cash payment equivalent to a 50% originally of the sick day leave, and then later amended to 20%.
Right. I know what the manual states, but is the manual part of the employment agreement?
The manual,
in this case, was it part of the employment agreement?
No, it was not, and it's our contention in this case that it did not become part of any implied employment agreement.
Mr. Keating, it is true that it was an incentive program, right? Not
Correct.
To use your sick days.
Yes.
He certainly, whether he signed for the manual, I'm assuming you wouldn't disagree that employees knew that that the Turnpike Authority had this policy.
No, I wouldn't I would not contest that, Your Honor. But
So he's conducting himself as time goes on in reliance on this policy, right?
He is conducting himself in reliance upon the policy, but I think you're...
Well, can I just answer to that? I mean, he may be conducting himself in reliance on the policy, but the policy is you don't take sick time unless you're sick.
Correct.
So if he is working and if he is able to work, the policy is you work, you don't take sick days unless you're sick, and if you can work...
But it also says, unless it's absolutely necessary.
Yes.
And I think the evidence is that there were certainly times that he could have legitimately taken sick time that he didn't in
Correct.
reliance on this policy.
Correct. That's correct. But let me, if I could suggest, I think you're skipping over the most important consideration here. The most important consideration is whether the employee manual as a whole became part of an implied employment agreement, not whether within that manual there was a specific benefit or held out by the Turnpike Authority. I say this, Your Honor, because if you look at the cases that this Court has decided on whether or not you construe from a personnel or employee manual an implied employment agreement or obligations on the part of the employer arise out of that particular manual, you have to look, according to the Court, at a lot of different circumstances, and those circumstances are set forth particularly in the O'Brien case, but prior to the O'Brien case in the Jackson case. I think the error that the appeals court made in this case was it bore down within the manual to the provision that dealt with sick leave benefits and ignored, it didn't really ignore, but it decided that the employment manual did become part of an implied employment agreement, which we say was wrong.
But in Jackson, just take Jackson first. The whole discussion is about the procedural requirements, the disciplinary requirements,
Correct.
right? I mean, it's,
And in
And the same
O'Brien, it
with
was
O'Brien.
about the termination without
right.
cause.
So the discussion was zeroing in on the particular provisions that were at issue, which is the same here, isn't it?
It's not, well, let me make two answers to that question. First of all, in both of those cases, the analysis by this court was in the context of whether the employment manual as a whole became part of an implied employment agreement. It was the only reason they paid attention to whether or not, whether there was an employment agreement, whether or not there was a term to the agreement, whether or not the employer retained the right to change the terms of the agreement, whether or not there was negotiation for the agreement. In Jackson and in O'Brien, there is a list of what I believe O'Brien calls circumstances, which are none of which are prerequisites, but which the court is required to take into account before it gets to the question that you posed, which is whether or not within the sick leave policy there was a promise, an acceptance. And I think where the appeals court and where things like gratuitous payments come out is focusing so much on the specifics of those clauses and not looking at whether or not the agreement, the manual as a whole, should be deemed to be part of an implied employment agreement. Now, I see you shaking your head, but I just want to add.
I guess the problem I'm having, I hear what you're saying, but both O'Brien and Jackson are cases where the issue at hand were procedural rights.
Correct.
And I guess I'm just thinking, and I'm not going to be able to articulate quite how, but this does seem different because we're really talking about substantive rights here. That is, a right to certain monies or certain benefits in exchange for following a policy that, changes over time.
But I think what happens, if you look at it that way, is it leads you down a path which is inconsistent with O'Brien and Jackson. Then you get in. Excuse me.
go ahead.
Then you get into questions about whether or not the amounts were vested, whether or not they were earned and credited prior to his retirement, or whether or not he had to, in fact, reach a retirement or death to receive the benefits.
Well, of course he did.
Pardon me?
Of course he did. I mean,
Well, in the appeals court decision, it doesn't say that. In the appeals court decision, it says retirement was only the time of payment. It wasn't the occasion which gave rise. Under the policy itself, you must work until retirement or death to be eligible for the payment.
Could you have changed the defendant's weekly wage after he started working?
Could we have changed?
Yes.
Presumably, it was an employment at will situation. I suppose you could have changed the weekly wage, at least on a prospective basis. I assume you could.
But so you're right. Okay.
If this employee had gotten sick, seriously ill, could he have taken all the accumulated sick leave before retirement?
Your Honor, the manual, I'm afraid the manual answers that question. I'm not sure you're permitted to take more than a certain number in a particular year. The way you build up your credits is you don't take more than 4.5 days in a particular year. I just don't know the answer to whether you could have assumed that you would have taken all 403, which is the number he had. My assumption is you probably could if you were seriously ill, but I just don't know the answer to that question.
If this is somewhat irrelevant, but if has the Turnpike figured out how many people might qualify under this program if we uphold the appeals court and what it's going to cost them?
Well, I think one of the reasons that we're here and that we asked for further appellate review, Your Honor, is because we feel it would have an impact on a number of other employees, but I don't have a quantification of that.
But it'll be millions of dollars, won't it?
Could be a lot of money. I mean, I think that the appeal here, I think, is really premised on the notion that an affirmance by this court would make that employee manual, applicable as part of an implied contract.
It has to.
Yeah,
it has to be
right.
the whole. It has to be the whole manual.
It has to be the whole manual. That's our.
I mean, at least under O'Brien and Jackson, you can't just say, "Well, it's just this little piece of it."
That is our contention, and our contention with regard to the way the appeals court addressed it was with all due respect, put the horse before the cart before the horse. They began to look at the specifics of this particular provision and then drew all kinds of conclusions about offers, acceptance, unilateral contracts, and whatever, without looking at the entire employment manual as to whether or not it became part of an implied contract.
Well, should you prevail because there's a question of fact as to what the employment contract was to begin with?
Well, there certainly is a question of fact. If I'm thinking of what you're thinking of, Your Honor, they're even remanding the case, even under the appeals court decision, it's remanded to the Superior Court because there's some confusion as to what actually constituted the contract and the various
Well,
rights.
isn't that the first question?
Yes.
The very first question is what constituted the employment contract?
Right.
And that is not clear. I mean, it may not be clear on this record.
I think it's agreed that Mr. LeMaitre was an employee at will, that he had no employment contract. There was no term to the contract at all. In fact,
And an oral. I mean,
Pardon me?
there was an oral agreement. I mean, you come to work and we'll pay you.
Correct. And you get terminated or you stay on. And I think that the one thing I'd like to mention, that I wanted to mention in response to Justice Botsford a minute ago, is if you look at the O'Brien-Jackson factors, or circumstances, as O'Brien calls them, they actually, in our case, this case, mitigate in favor of the Turnpike Authority. The various, and I have listed them here in my outline. I won't go through each of them now, but the fact that they could, I'll do a couple. They could make changes. There was no negotiation. There was no employment agreement. There was no term of the agreement. All of these things under Jackson and O'Brien would suggest that the manual did not become part of an implied employment agreement. The court below and the Superior Court found otherwise, but we think they found incorrectly otherwise. And but also they found, as I say, zeroed in on the sick leave policy particularly.
Is there parts of either or both of those cases where there is a discussion that it's talking about the whole manual as opposed to?
Well, there's an interesting quotation in O'Brien, Your Honor, from a case from New Jersey called the Woolsey case, in which it talks about said we don't mean to diminish the specific terms of the agreement, but the focus, I'm trying to find the quotation for you. I will. Just one moment.
Woolley versus Hoffman LaRouche.
The Roche case.
Was that the 1985 one? Is that one?
Yeah.
Yeah, it's cited in the O'Brien case, and it says.
It's on page 849, I think.
Pardon me?
On page 849 of O'Brien?
Without minimizing the importance of its
I'm
specific
sorry,
provisions, the context of the manual's preparation and distribution is
Yes.
to us the most persuasive proof.
Yeah. Yes, that at least is one. Thank you, Justice Cordy. That is one of the references in the record to this particular point. But I think if you look at the decisions as a whole, and I would acknowledge that they both deal with either grievances or termination. That's quite clear. I think they look at those provisions within a larger context, which is the larger context as to whether or not the manual itself becomes part of an employed.
I think it would be very, I mean, apart from anything else, and I think there is language, and I'm looking at O'Brien and O'Brien was clarifying Jackson. So,
Yes.
And O'Brien is speaking in terms of the manual. But one of the things that is complicated here, if you don't look at the whole manual, is that an employer starts on day one, the employee starts on day one, and the employer retains the right to amend, and in fact does amend going on along the way.
Yes.
May or may not amend one or two or three parts.
Right.
Then the employee gets all of the benefits. There may be increased benefits under the amendments.
Right.
There may be more personal days added. There may be all kinds of things added.
Right.
But all the time the employer is saying generally, I can amend this policy
Right.
at any time.
Right.
I mean, that's really what the court is looking at.
Right. And frankly, in this case, I don't think that the appellee contests that we had the right to amend because was no protestation in 1996 when we amended the sick leave policy to reduce it from 50% to 20%.
You could, though, have stated in the manual somewhere that it was provided only for guidance, such as in the Jackson case.
Well,
But
that's
you don't.
we say it's provided for convenience.
Well, but that's the
But
convenience
it doesn't say, it
guidance.
doesn't have, quite correctly, Your Honor, it doesn't have the explicit disclaimer, but we don't believe, and we think the appeals court focused on that provision as if that would be a prerequisite to the authorities preserving the right. And I think it is one of the circumstances.
Oh, but it would certainly help, and he could be even more direct. This is not a binding agreement.
That's correct. And perhaps going forward, people would do it.
I think that's what O'Brien tried to do, is to say these are not rigid factors,
Right.
because not everybody who's trying to do,
Right.
you know.
The appeals court, however, interesting enough, said the absence of doing that was virtually, I think, if you read the appeals court, was one of the key factors in finding that this did become part of an implied employment agreement. So I just say in conclusion, Your Honor, I think we're here because we believe the appeals court deviated from the O'Brien and Jackson standards by not looking at the circumstances as a whole and determining whether the manual was part of an implied employment agreement.
Thank you
very much.
Mr. Keating. Ms. Caprioli?
Thank you. Good morning, Your Honors. May it please the Court, Nicole Caprioli. I represent the plaintiff appellee, Robert LeMaitre. And there's two factors I just would like facts to bring to the Court's attention. One is that Mr. LeMaitre, in the first 21 years of his employment, from 1975 to 1996, when the policy was in effect that provided for a 50% cash payment and a 50% medical escrow payment, had virtually perfect attendance. And that's what the MTA had asked of him.
I understand that, but as you heard my question to Mr. Keating, is there evidence in the record that says, I mean, he might have had a perfect attendance. Lots of people have perfect attendances, even when they are fully entitled to full benefits. I mean, even when they're entitled to no benefits. Even when they're entitled to no benefits. And the whole point about these sick leave policies is that they are for sick time, not for other time. So there might have been, you know, some time that he could have if he had wanted to, but that doesn't mean that he can surely not claim. It would be a strange policy if you could claim for days that you wouldn't be entitled to sick time anyway, wouldn't it?
Well, the difference with this policy, Your Honor, is that it was not gratuitous in nature. The MTA asked its employees, please only use your sick time when it is absolutely necessary.
Well,
if you do that, we'll reward you. And the policy allowed employees to use sick time for medical appointments, eye appointments, dental appointments, in addition to feeling under the weather, recovering from surgery, sustaining an injury. So as the unrefuted affidavit of the plaintiff shows, in reliance on their policy, in reliance on them saying, we will reward you if you don't use your sick time.
That may be the case, but the question is that part of the contract?
Did the plaintiff rely on the manual in taking the job?
No, I don't believe the record would show that he relied on the manual when taking the job, but certainly throughout.
That's part of the problem. That's part of the problem. It doesn't have to be right immediately, but it's part of, I mean, backtrack. I think my concern is if you can't just have one piece of it and not the other pieces of it.
But the manual was in place from day one. The manual was presented to him from day one.
But that happens in lots of cases, and it doesn't make it an enforceable contract.
But in this case, Your Honors, I think that the distinction here is that it's not a gratuitous benefit. The employee had to do something in exchange in order to get the benefit.
But that is often the case.
And having done what they asked him to do.
Only if it's part of your contract.
Well, but in this case, we would say it is part of his contract.
No, I understand that, and that's what I'm saying.
Is it part of his contract because he did what
O'Brien and Jackson said?
Or is it part? Yeah, I guess my question here goes to whether or not you are focusing simply on the circumstances of this benefit, which I understand your argument. I mean, surely if there's an incentive not to use sick time and to minimize it, people might well respond to that incentive, and therefore they would reasonably expect that they would get the benefit that is supposed to be attached to that. But looking more broadly at the manual itself, is that part of the implied employment contract here?
Yes, we would say it is.
Because of this benefit or because of something else?
The employment manual states, and the subsequent policy bulletins state that these are procedures of the MTA and that these are going to be governing policies of the MTA. And there's examples of that at pages A48, A57, A65 of the record. These are procedures and policies of the MTA.
Then surely your argument is that the entire manual meets the O'Brien and Jackson tests, and we don't have to look at any reliance or anything else with respect to the sick leave policy.
I certainly have not looked at all provisions in the entire employment manual. I've certainly been focused on the sick leave policy, which is a part of
what
the
I'm saying
manual.
is your legal argument, not that you've gone through all the pieces, but that this manual meets the O'Brien and Jackson test. Let me put it this way. You can have a supervisor who says to his employees, you know, we really want to have a perfect attendance records here. I've noticed that a lot of sick time is taken on Fridays, and there will be consequences if you take sick time on Fridays unless you can really substantiate it. And in reliance on that, this, by the way, emerges midterm. In reliance on that, it's a supervisor, agency law, he can bind the company, does not become part of the contract, does not become part of the contract. That is fundamental employment law. And that's the issue in this case. It may be unfair, it may be terribly unfair, but the question is it part of the contract? If it is, then the entire manual is part of the contract, and probably the manual at the time that he was hired.
Certainly the sick leave incentive policy, which was remunerated on at least 6 occasions by the MTA without change, is part of a binding contract because it was a bargain for exchange. The MTA said you only get this benefit if you do something in exchange. And
What was the consideration? Continuing to work?
not only continuing to work, but
and not take
using your sick days only when absolutely necessary.
But you-
Foregoing legitimate time when you could have used your sick days.
Did it define the sick leave benefit itself, the manual? Did the manual say each employee will obtain sick leave at the rate of 1 2/3 days per month?
It did, Your Honor.
Is there any other source, oral communication, written contract, is there any other source that those were the terms of the sick leave benefit?
As to how an employee would
receive and
it,
accrue sick leave?
there's multiple policy bulletins and summary sheets that were handed out at regular intervals by the MTA.
Apart from the manual?
Yes, there's the employment manual, and then there's policy bulletins. And the MTA says it's the policy bulletins that are the governing documents, and those are handed out at different intervals.
But
They were
policy bulletins often don't become part of a contract. There are lots of policies. One policy might be you can only take sick time, when it's a real emergency. Otherwise, we're going to dock your pay. Right?
But that wasn't this MTA's policy. The MTA's policy was you get 15 sick days a year, and if you don't use them, we will there's a value associated to them. We will pay you 50% cash value, and we will escrow. And the MTA used the word escrow, which I think a layperson, an employee, like the plaintiff, would understand the word escrow to mean some
Understand
kind
the
of
word what?
escrow.
Oh, escrow.
To mean some kind of banked or vested right, that it's not something that the whim of the management of the MTA can take away. They're telling you, if
But
you do A, we will do B.
unfortunately, if it's not part of the contract, new management can. That's the whole point about policy manuals changing. You may not like it. You may not like employment at will.
Well, but this court in O'Brien has said that an employer can unilaterally make an offer, which the MTA did. It made an offer to its employees. We will reward you the value of your sick time if you use it only when necessary. And in O'Brien, this court has said that an employee can accept that offer, which Mr. LeMaitre did. He accepted it by, 1, continuing to work after the offer was made, and 2, he relied on the policy. He had a reasonable expectation that his reliance would be fulfilled, and he did as the MTA asked him to do. And in that circumstance, where the MTA has freely offered a bargain for exchange and the employee has accepted it and performed in reliance on that promise, a contract is created. And
If he had the contract, how could the Turnpike Authority unilaterally change it and to say, well, it's no longer 50-50, it's now something else?
Certainly, we've never disputed that going forward, prospective changes, the MTA was free to
If you
make.
have a contract, if you have an employment contract that says, these are my benefits,
I think the appeals court logic and their reasoning is sound. What the appeals court has held is that each period of time, from first policy bulletin to second policy bulletin, is the contract term. And when the new policy bulletin or manual comes out, the employee has the option.
But if I, excuse me for interrupting, if I employ you on a certain term, and then I unilaterally change the terms, the ones to which you have not agreed, right? And you say, no, I want to, I want the original bargain.
No, isn't the argument that the agreement is, for whatever period of time a policy bulletin or the manual's in place, these are going to be the terms? You have the right. I agree, employee says. You can change this MTA, but for the time that this was in place, I get it.
That's exactly right, Justice Botsford. For the time that it's in place, I get it. And you can change it going forward. And I, as the employee, can say, that is unacceptable to me and I will no longer work under that term, or I agree to the new term. But the issue is I agree to the new term prospectively, going forward. I don't agree that you can change the contract today and wipe out all the prior terms that I had worked under, all the benefits that I had vested in and earned. It's a prospective change. And what the MTA has tried to do in this case is retroactively change it. In 1996, they tried to wipe out 21 years of earned and vested benefits that the plaintiff had had. They didn't make a prospective going forward change. They made a retroactive
Anything in the policy
change.
that said they couldn't make a retroactive change?
There's nothing in the policy either way. And I think that both
Well,
common
the
law
policy
and-
says they can change it in any way they want to, doesn't it?
I'm sorry.
Doesn't the manual say they can change it in any way they want to?
It doesn't. It doesn't say, it's silent on the issue. So certainly, while they could change it going forward, how could they change something that an employee has been vested in and earned going back? They can't.
Did the employee get periodic statements of how many sick days they had accrued?
I believe that he did. It's not in the record before the court, but I believe that he did.
Now,
And on page A70 of the record, there is a statement showing yearly how the time is accrued.
is there some fact question here, whether the manual became part of the employment contract?
I don't think it's a fact question. I think that both the Superior Court and the Appeals Court looked at it as a question of law, that O'Brien has held that employment manuals certainly conform implied binding contracts between employer and employee. And O'Brien has also held that the employer does not have to intend to make that offer or binding contract to the employee, that by simply putting something out there that the employee reasonably believes to have been a bargain for exchange, and the employee then relying and acting upon that, a contract can be created. So I believe that's a legal issue, not a factual issue in this case. And the record clearly demonstrates that Mr. LeMaitre relied upon the contract. His affidavit is unrefuted. There's at least 6 reiterations without change by the MTA over a numerous span of time of the exact same policy, reiterated to the employees on at least 6 occasions, the most recent one being 1994, prior to the change. And the
Ms.
MTA...
Caprioli, do you agree with Mr. Keating that we have to make a determination whether the entire manual was part of the contract, which may in turn, and not just this provision?
I'm certainly not suggesting that, the court look at this provision in a vacuum, but this provision is isolated in multiple policy bulletins.
No,
which
I
are
understand
governing
that,
documents.
but my question to you was, do you agree with him that we have to, in order to reach your question, which may be a subsidiary one, namely whether the subsequent amendments were enforceable, that we have to first conclude that the manual as a whole was an enforceable agreement?
No, I think that this court can look at the policy bulletins and the sick leave incentive policy, and it can stand on its own.
In
this
isolation?
case. In isolation, because
Do we
it's a
have anything
bargain.
in either of the cases that are being relied upon here and debated here, O'Brien, I think the other one's Jackson, that says acceptance of one provision of one of these policies is acceptance of the whole manual?
I'm not aware of that in either case.
That wouldn't
but-
seem to make much sense, because suppose you had another provision in the manual, and I don't know if this one has such a provision that says we're going to grant this benefit, but this is purely gratuitous, and no one is to rely on it, and et cetera, so forth. I don't think we'd say at that point that could not be broken out and was unenforceable. Right?
Well, Your Honor, if I'm understanding your question, you're saying if the manual,
In your favor, the question.
right,
These manuals can
The
be
answer is
divisible.
right.
You don't have,
But if it's got terms like that, it's part of the contract, by the very terms of the contract.
correct.
But the difference between this and Jackson and O'Brien, besides this procedural substance, is that I take it that in Jackson and O'Brien, the version of the manual that the employees were relying on was the version in effect at the time that the action that they were concerned about happened.
I think that's correct.
Whereas here, it's a version, I mean, it's versions going back.
But I
Because
wanna-
you don't disagree that as of 1996 and going forward to 2002, if that's when your client left, that it's the 20% version that applies.
Yes, and I'd like to make that clear. From 1996 until the date of retirement, Mr. LeMaitre said, that's the change going forward, 20%, I accept it, and I will continue working. We're talking about 1996
Did the sick leave
then.
policy contain the provision that said we can amend this at any time?
No.
So you're just saying that, you know, it was a contract, but they could unilaterally amend it?
They could unilaterally amend it.
I think that
going-
has very severe consequences for employees.
But the distinction, if I may, Your Honor, and I recognize that I'm
No,
out
you
of
can answer
time,
the
the
question.
distinction is that this is a non-gratuitous benefit. Certainly a gratuitous
No, but
benefit is
if it's
not part-
non-gratuitous, it's even worse. So I have an agreement that as part of my contract that I'll get this number of days a year, and then the employer, even though it's part of the contract, bargained for negotiated consideration at the beginning of the term, can just unilaterally, when it hasn't said it can do that, can just change the terms, and then says in essence, well, you want the job, here are the new terms.
Under
I
an
think that
employee
had-
at will situation.
I think that has very severe consequences for employees, very severe.
Well, isn't that what Mr. Keating argued? I think I asked him about if he could change, if the T could change the benefits.
Only because
And he
it's
said that
not-
they could change the pay.
Well, because
So-
that was part of because there's no suggestion that it was for a term.
Correct. So when the employee was working under policy number 1 that said 50/50 cash escrow value, and then the MTA said, going forward, it's going to be 20% cash only, the employee had the option to not continue to work under that
And
agreement.
that's a terrible sword to hold over people who have a contract.
But, Your Honor, I believe because it's an implied contract, and because
Doesn't make any
it-
difference. An express or implied contract is absolutely enforceable.
Well, it's an at-will contract, and it can be changed at any time prospectively.
Correct.
According
And
to
that's,
you.
that's our
The length
position.
of employment can be you have to terminate somebody.
Well, or the terms under which they're working prospectively can be changed going forward.
Not necessarily. Thank you.
Well, thank you for the extra time.